So good afternoon, everyone. I'm Rebecca Scharf. I'm an associate professor of law here at the William S. Boyd School of Law. We're so excited to have you all here for this very important conversation. As most of you know, UNLV and the Boyd School of Law have been working over the past year with partners around the city and the state on public and private policy initiatives related to unmanned aerial systems in Nevada. Okay, those partners include Fennemore Craig, the Desert Research Institute, the Departments of Criminal Justice and Engineering at UNLV, as well as the Governor's Office of Economic Development. Hey, I began studying the intersection of privacy and technology after first teaching privacy law in 2007. I can tell you that nowhere does that intersection present itself more prominently now than in Nevada around the context of unmanned aerial systems. On the one hand, obviously and importantly, the UAS industry offers the potential for economic stimulus in Nevada. In Nevada alone, the UAS industry could have potential economic impact of over $2.5 million in untold jobs, including jobs in the technology industry. On the other hand, however, legal implications for the public and private use of this technology has become a growing concern. As you can see from Professor Joel Lieberman's important national survey on public attitudes around aerial drone systems, a majority of the public supports using drones for certain activities, such as military applications and search and rescue. While at the same time, a majority of Americans remain very concerned about drones monitoring people around their homes, considering it an invasion of privacy. Yet whether such monitoring is an invasion of privacy under the law is a complex question, raising numerous constitutional and statutory issues, depending on whether they are used by the government, by private industry, or even by contractors hired by the government. That is one of the many, many reasons that we are thrilled to have Dean Erwin Chemerinsky with us here today to help us grapple with these important issues and hopefully to move the conversation forward. For those of you who have never heard Dean Chemerinsky speak, hey, you're in for a real treat. But just a few key highlights from his very impressive biography. Dean Erwin Chemerinsky is a Harvard Law graduate and the founding dean and distinguished professor of law and Raymond Pike Professor of First Amendment Law at the University of California Irvine School of Law. Dean Chemerinsky is a national expert, and some would say the national expert, on constitutional law, civil liberties, and appellate litigation. He's the author of over 200 prominent law review articles, as well as 8 books, most recently, The Case Against the Supreme Court, which was just published by Viking Press in the past month. He frequently argues cases before the nation's highest courts, including many before the United States Supreme Court. I give you Dean Erwin Chemerinsky.
Thank you so much for this reading. Thank you. Thank you so much for the kind introduction. Thank you for inviting me here today. I've learned so much for the first couple of hours of this conference. Among the disturbing images from Ferguson, Missouri this summer was seeing the police there using military equipment against demonstrators. We learned that across the country, local police departments are acquiring equipment that previously had only been possessed and used by the military. This military equipment includes what's commonly referred to as drones. What we've talked about this afternoon is the unmanned aerial surveillance systems. About the same time that this was going on in terms of reports of what was going on in Ferguson, Missouri, it was learned that police departments in California, in Los Angeles, and in San Jose had secretly acquired these unmanned aerial systems. We've learned police departments across the country are beginning to deploy them. It raises great concerns, the concerns we've been talking about today with regard to privacy. Soon after these reports this summer, the California legislature passed a bill, AB 1367, to say that police in California could not use these unmanned aerial systems except with a warrant issued by a judge. Just a few weeks ago, California Governor Jerry Brown vetoed that bill. This afternoon, we've talked a lot about privacy relative to these unmanned aerial systems. There's many ways in which these, which I'm going to refer to for just sake of simplicity as drones, raise issues with regard to our privacy. We're concerned about their gathering information about us. We're concerned that they gather information about us in ways that otherwise would be regulated by law. We've heard people this afternoon talk about the concern that these drones might look in people's backyards, over the 8-foot fence, peer into people's windows, monitor what conduct is going on. To be sure, there's other ways in which the government can gather that information. The police, with a warrant, can go into somebody's home. People can go onto others' property, but there's laws that regulate that. The Fourth Amendment limits the ability of the police to do that. The tort law of trespass limits the ability of people to do that when we're not talking about law enforcement personnel. We're concerned that once the information is gathered, it's possessed. It might be collated. What we're talking about with these unmanned aerial systems is the ability to gather in kind more, larger quantities of information than ever before. Because after all, if the only other way to go into somebody's backyard or into somebody's house, there's a limit how often that can happen. Drones, though, can be there so much more frequently, such a longer period of time, which means if it's the government doing it, they have far more information. If it's done by private entities, they too have much more information. And the more information that's possessed, the more it can be collated, the more that can be analyzed, the more that can be learned about us. And we're concerned from a privacy perspective of how it might be disseminated and how it might be used. Once the information is there, as people have raised in their questions this afternoon, there's real worries about how the government, how private entities might use it. So in all these ways, the gathering, the possession, dissemination and use of information, these UAS systems really raise important questions with regard to privacy. Someone said this afternoon, isn't it the case that we already have enough laws to deal with privacy? My thesis this afternoon is we don't. That the laws that exist with regard to privacy are grossly inadequate to deal with this new emerging technology. In fact, my central thesis is that we're a uniquely important moment in history. We're at the start of the use of this technology. There's the ability to put regulations in place from the very beginning. And that's what we're talking about this afternoon. In this regard, I want to make three main points. First, I want to suggest to you that traditional Fourth Amendment principles are insufficient to deal with the unmanned aerial systems. Second, I want to argue to you what we really need to do is to develop protection of informational privacy. And then third and finally, I want to suggest with regard to these unmanned aerial systems, we need both legislative and judicial action, and we need it both at the state and federal level. So let me start by talking about the Fourth Amendment and its traditional principles and why they are so inadequate here. In fact, if you look at the course of American history, the Supreme Court has been way behind the times in adapting the Fourth Amendment to new technology. The first major Supreme Court case about the Fourth Amendment and surveillance technology was Olmstead versus United States in 1928. The issue in this case was whether it's a search within the meaning of the Fourth Amendment for the police to engage in wiretapping if they don't have to enter the premises. Obviously, this was early in American history with regard to the existence of telephonic communications. It's the first chance the Supreme Court had to deal with wiretapping relative to this new and increasingly pervasive technology. And the Supreme Court held that it is not a search, and therefore no warrant is required if the police can engage in wiretapping without a physical trespass. So if the police can put their devices on the wires outside the home and then hear the conversations, no warrants required, no Fourth Amendment application. It wasn't for almost 40 years, until 1967, in Katz versus United States, that the Supreme Court overruled Olmstead. Katz involved a gambler engaging in transactions from a phone in a telephone booth. I worry now when I teach this case to my students, they no longer know what a telephone booth is. The Supreme Court, in an opinion by Justice Potter Stewart, said that the Fourth Amendment protects persons, not places. The court said that the Fourth Amendment provides protection so long as there's a reasonable expectation of privacy. In other words, if the police engage in wiretapping electronic surveillance, even if there's no trespass, it's still a search within the meaning of the Fourth Amendment. And of course, that has to be the law. But isn't it amazing that it wasn't until 1967 that the Supreme Court finally said that it's a search even if there's no physical trespass? There's problems with the Katz approach with regard to reasonable expectation of privacy. How is it determined whether people have a reasonable expectation of privacy? Is it descriptive? Do we have to do surveys like those that we heard earlier and see what people really do expect? Is it normative, what people should expect? What if the government tells us in a particular instance not to have any expectation of privacy? That happens at airports today. There's a sign in front of every airport that once you enter, you can be searched. Have no expectation of privacy. Can the government just extinguish our privacy by telling us to have no expectation in a particular instance? Also, and we've touched on that this afternoon, Katz provides no protection of privacy when people are out in public. Because once we're in public and we can be observed, then there's no longer any expectation of privacy. Katz remains the model for the protection of privacy under the Fourth Amendment. And yet it's one that seems so ill-suited to dealing with technology of the 21st century. Let me point to two Supreme Court cases. One from a quarter century ago that I think is right on point for what we're talking about this afternoon, and the other from just a couple of years ago to show you the inadequacy of Fourth Amendment's traditional principles in this area. I'm surprised that the case from 1989 of Florida versus Riley hasn't been mentioned here this afternoon, because it is as close as you can come to a Supreme Court case that's on point in terms of whether or not the use of unmanned aerial systems is a search within the meaning of the Fourth Amendment. Riley involves the police using a low-flying helicopter to observe what was going on in somebody's backyard. The helicopter was flying at 400 feet, which was below the FAA-approved level for such vehicles. It was looking in the backyard area behind somebody's trailer. And the question was, is this a search within the meaning of the Fourth Amendment? The Supreme Court, 5-4, said it was not a search. Now, what this means then is the police would not need to get a warrant before going in a helicopter to look in somebody's backyard. There would not be a requirement for probable cause in order to do this. It means that the police in their low-flying helicopter can look in any of our backyards, and there would never be a need to follow the principles of the Fourth Amendment. I assume then that Florida versus Riley is the controlling case if there's a challenge to the use by the police of drones to look in people's backyards, maybe even to look in their windows. The other case that I would point to in terms of the inadequacy of Fourth Amendment principles is a more recent case from 2012. It's a case called United States versus Jones. Antoine Jones was a suspect with regard to cocaine trafficking. The police got a warrant to tap his telephones. The warrant also authorized placing a GPS device on his phones. Tapping his phones. The warrant also authorized placing a GPS device on his car. The warrant specifically said that the GPS device had to be placed on his vehicle within 10 days after the issuance of the warrant and the GPS device had to be put on the car while it was parked in the District of Columbia. Inexplicably, the police waited until the 11th day after the issuance of the warrant to put the GPS device on the car, and they put it on the car while it was parked in the state of Maryland. So everyone in the litigation agreed there was not a valid warrant when the GPS device was put on his vehicle. For 28 days, the police monitored the movements of Jones' car through the GPS device on the undercarriage. When Jones was prosecuted of cocaine trafficking, those GPS logs were key evidence against him. He was convicted. He was sentenced to life in prison. The issue before the Supreme Court was whether it violated the Fourth Amendment to put a GPS device on his car without a valid warrant and then monitor his movements for 28 days. I have long had a predictive principle about the Supreme Court and the Fourth Amendment. If the justices can imagine it could happen to them, then it violates the Fourth Amendment. At the oral argument, Chief Justice Roberts at one point said to the attorney for the United States, Michael Dreeben, was it the government's position that it could place a GPS device on the bumper of Roberts' car without a warrant and follow him around? Justice Kennedy immediately followed up and said, was it the government's position that a police officer could slip a GPS device in Kennedy's pocket and follow him around without a warrant? I knew at that moment it was all over for the United States government. The Supreme Court 9-0 ruled against the United States government, saying that in this instance a valid warrant was required. Justice Scalia wrote a majority opinion joined by 4 other justices. Justice Scalia began his opinion, as he often does, by saying that the Fourth Amendment means the same thing today and was adopted in 1791. I confess that I find it incongruous when his next sentence was, we have to decide whether a GPS device on a car violates the Fourth Amendment. But Justice Scalia found in 18th century English law precedent, Entick versus Carrington from 1765. And he said, under Entick versus Carrington, this would be regarded as a trespass. He said, surely the framers of the Fourth Amendment in 1791 knew of Entick versus Carrington. A trespass is sufficient for a search. Justice Alito wrote an opinion concurring in the judgment, joined by 3 other justices. He said, we shouldn't focus on 18th century English law in deciding what's a search in the 21st century. He said we should focus on whether there's an invasion of the reasonable expectation of privacy. He said, at some point in the 28 days, monitoring Jones' movements was a search within the meaning of the Fourth Amendment. I want to suggest to you that neither the approach of Justice Scalia nor that of Justice Alito is likely to be very useful when it comes to the technology of the 21st century, like that which we're focusing on this afternoon. Imagine the movements of Jones' car had been followed, not by a GPS device on the undercarriage, but by cellular technology. Or, as someone suggested in the last panel, by satellites. Or, based on what we're focusing on, by drones. I'm reasonably confident that not even Justice Scalia can find an 18th century English law precedent to help us know when cellular technology or satellites or drones are searched within the meaning of the Fourth Amendment. But nor is focusing on the reasonable expectation of privacy very useful here. We don't have any expectation of privacy when we're driving on public roads. If the police wanted to have an undercover agent follow Jones everywhere he drove for a month, that would not require a warrant. In fact, more generally, we don't have privacy interests when we're out in public, not only under the Fourth Amendment, but not under the First Amendment either. The leading Supreme Court case here from 40 years ago was a case called Laird versus Tatum. It involved the Army spying on peaceful civilian demonstrations. And the Supreme Court found that a mere claim that it was chilling speech was not enough to have a claim under the First Amendment. The court stressed, what we do in public is there for the world to observe, and it can't be claimed that government monitoring is in any way an infringement of First Amendment freedoms. So this is why I say that I think the traditional Fourth Amendment Even First Amendment principles don't help us in dealing with the threats to privacy that are created by drones, these unmanned aerial systems. Well, this then brings me to the second part of my remarks. I think what we really need to do is to develop a theory of informational privacy. I think only a well-developed theory of informational privacy can deal with this technology of the 21st century. In my remarks so far, the panels earlier today have repeatedly used the word privacy. But I think privacy is a very imprecise term. If you think about it, both in terms of the Fourth Amendment and in terms of tort law, we often use the word privacy to mean several different things. One thing that privacy is often about is protecting us from intrusion. That's really what the Fourth Amendment is historically about, protecting us from the police coming in and searching our homes, or protecting us from the police search our persons, unless the police have a warrant and probable cause. But it's very much a focus on protecting us from intrusion. The tort of trespass is again about protection from intrusion. A second way in which we talk about privacy is often in terms of informational privacy. This is about protection with regard to the gathering of information, or the possession of information, or the dissemination of information. Here there are federal statutes to protect privacy in particular instances. There's a federal statute that limits the dissemination of health information. This is commonly referred to as a law about privacy. There's the Federal Video Privacy Protection Act. You might remember that when Robert Bork was being considered for the Supreme Court in 1987, people went and got the records of the videotapes that he had rented from a local video store. Maybe my students will respond to videotapes in video stores like phone booths. But Congress then protected, and has since amended, the Video Privacy Protection Act that limits the ability to access information about what videos somebody is buying from a video store or now getting from Netflix. Again, the focus there is on informational privacy. In the tort law context, there is a tort of public disclosure of private facts. It's about creating liability if people reveal information about others, where there would be an expectation of secrecy, where disclosure would be offensive to the reasonable person, and it's not a matter of public concern. There's a third way in which we use privacy, and that's protection of autonomy. Here I think of the landmark Supreme Court case of Griswold versus Connecticut in 1965, where the Supreme Court declared unconstitutional a Connecticut law that prohibited the sale, distribution, or use of contraceptives. Justice William Douglas wrote the opinion for the court, and he said, quite famously, that privacy is protected by the penumbra of the Bill of Rights. He talked about how within the idea of the First Amendment, and the Second Amendment, and the Third Amendment, and the Fourth Amendment, and the Fifth Amendment, there are notions of privacy. One commentator said, Douglas was like a cheerleader skipping through the Bill of Rights and saying, give me a P, give me an R, give me an I. I found privacy in the penumbra of the Bill of Rights. But many Supreme Court cases through history have protected privacy in the sense of autonomy. In the 1920s, the Supreme Court protected the right of parents to control the upbringing of their children. Since then, as aspects of privacy, the court has protected autonomy with regard to the right to procreate, the right to custody one's children, the right to keep the family together, the right to abortion, the right to refuse medical care, the right to engage in private, consensual, same-sex sexual activity. All of this we refer to also as privacy, but in a very different sense than we're speaking of privacy this afternoon. Here it's privacy with regard to autonomy. What I want to suggest to you, though, is that while the law is very well developed in terms of protection of intrusion, and very developed with regard to protection of autonomy, the law is not very well developed with regard to the middle type of privacy, protection of informational privacy. And that's really what's key when we're talking about unmanned aerial systems. Let me talk about this in terms of the Constitution, in terms of statutes, in terms of tort law, all of which I think go to the question asked at the first panel, do we have enough law? There is very little in the way of constitutional law concerning informational privacy. In fact, the most the Supreme Court has ever said is it would assume that there's a right to informational privacy, but not decide the question. There was a Supreme Court case, 1977, called Whalen versus Roe. New York had a law that required that when doctors prescribed certain controlled substances, they had to fill out a form. The form had to list the doctor's identifying information. It would also give the patient's identifying information, name and address, and it had to include the type of drug that was prescribed. And all of this was then kept in a central agency in the state of New York. And the claim was made that this was an invasion of the right to privacy. The Supreme Court, in an opinion by Justice Stevens, upheld the New York law. The court said, as I already alluded to, that it would assume that there was a right to informational privacy, but had no need to decide the question. It said that New York's law served a sufficiently important interest with regard to regulating controlled substances, thus it didn't violate the Constitution. It wasn't until 2011 that the Supreme Court returned to the issue of informational privacy. The case was NASA versus Nelson. After September 11th, regulations were adopted to increase the screening and security clearances for those who worked in the federal government and those contracting with the federal government. This case involves a person who worked at the Jet Propulsion Laboratory at Caltech and was employed pursuant to a federal contract. As a result of the terms of the federal regulation, among the things he had to disclose is whether he'd ever received psychological treatment or therapy and whether he'd ever used any prohibited substances. He brought a challenge to this, saying to require him to disclose this information invaded his right to privacy. He said there's nothing with regard to his job functions that in any way could endanger national security. And essentially, given what he was doing for the government, it was none of the government's business whether he'd ever received therapy or whether he'd ever smoked marijuana. And of course, he said, this is information that's very private, especially with regard to the psychological treatment that he might have received. The United States Court of Appeals for the Ninth Circuit ruled in favor of Nelson. The Ninth Circuit accepted his claims with regard to privacy and the lack of a countervailing government interest. The United States Supreme Court unanimously reversed the Ninth Circuit. Justice Alito wrote the opinion for the court. Just as in Whalen versus Roe, the Supreme Court said it would assume that there was a right to informational privacy, but it had no need to decide that issue. The court said that the government had a sufficient interest in making sure that those who were working pursuant to a government contract at the Jet Propulsion Laboratory disclosed information, including whether they'd ever received therapy and what drugs they had used. Justice Scalia and Thomas concurred. And Justice Scalia said, quite forcefully, there is no right to informational privacy protected by the Constitution. Justice Scalia said, no prior Supreme Court case has ever recognized a right to informational privacy. None should be found to exist. I would point to one other case, an even more recent decision, that reflects the lack of concern by the court with regard to informational privacy. It's a decision from 2013, Maryland versus King. It involves a Maryland law that says if a person is arrested for a serious crime, DNA would be taken, and the DNA would be obtained to see if it matched an unsolved crime in the police database. Alonzo King was arrested for an assault in Maryland. There's no dispute that he committed the assault. He admitted it to the police officers. There were eyewitnesses. Assault is a crime under the Maryland law where DNA is taken. DNA is obtained by a cotton swab inside the cheek. The DNA was analyzed not to relate it to the crime that King had committed. He had admitted that. But rather, the sole purpose was to see if it matched an unsolved crime in the police database. Several months after taking the DNA, the results came back. King's DNA matched that of a rapist from an unsolved rape. Additional DNA was taken under the Maryland law. King was convicted of rape and sentenced to life in prison. The question was whether taking this DNA violated the Fourth Amendment. The Supreme Court 5-4 ruled in favor of the police. Justice Kennedy wrote the opinion for the court. He said, the key test for the Fourth Amendment is one of reasonableness. He said, reasonableness is determined by balancing the law enforcement justifications against the privacy interests. He said the law enforcement benefits here are great in terms of solving unresolved crimes. He said the intrusion on privacy is minimal. It's just a cotton swab inside the cheek. He said this is just like taking fingerprints from a suspect. It's long been practice in police departments. Take fingerprints as part of booking. He said this is really no different. Justice Scalia wrote for the four dissenters. His opinion was joined by Justice Ginsburg, Sotomayor, and Kagan. Justice Scalia, writing for the dissenters, said, this is the first time in American history that the Supreme Court has allowed a search without probable cause or exigent circumstances. Justice Scalia stressed that this was a situation where the search was done to see if a person had committed a crime for which he or she was not in any way a suspect. Justice Scalia said, this is analogous to the old general warrants from England that the Fourth Amendment was meant to prohibit. Justice Scalia rejected the analogy to fingerprinting. He said fingerprints are taken from a person for purpose of quick identification. To the extent they solve other crimes, that's incidental. He said DNA isn't taken to identify a person. The results don't come back for many months. It's taken solely to see if a person committed a crime for which he is not a suspect. But I think both the majority and the dissent miss the importance of this case for informational privacy. A tremendous amount can be learned about a person from his or her DNA. What can be known about any of us, even from so-called junk DNA, is increasing exponentially each year. What does it mean when the government can have a DNA database of many, if not all of us? After all, in light of Maryland versus King, can't a state now say that every time a person is stopped by the police for anything, the police get to take DNA? What if a state says every time somebody goes for a driver's license, they have to provide a DNA sample? What if a state says at birth, DNA must be taken from every baby? If it's a question of balancing law enforcement gains against privacy, won't the court always, unless it focused on informational privacy, approve this? Because there's always great benefit in solving unresolved crimes. And if all the court cares about is that it's just a cotton swab inside the cheek, isn't the intrusion on privacy minimal? What the court was missing here was the concern with informational privacy. What does it mean for the government to be able to have a large DNA database? And what's it going to do with it then? So I've suggested to you then that the Constitution, as it's been interpreted by the Supreme Court, doesn't provide enough protection with regard to informational privacy. I'd suggest that statutes don't provide very much protection either. Now let me talk about this in the context of law enforcement. There are statutes that limit the ability of law enforcement to engage in electronic surveillance. The Omnibus Crime Control Act of 1968 says that whenever law enforcement wants to engage in electronic surveillance, they need to get a warrant from a federal court. And there are procedural protections, like minimizing how much can be listened to as part of that. There are logs and records that are required. Congress has created an alternative procedure when it's national security under the Foreign Intelligence Surveillance Act, but that statute clearly says whenever the police are engaging in electronic surveillance, they either have to get a warrant from an Article III court, a federal district court, or from the Foreign Intelligence Surveillance Court, which is comprised of Article III judges appointed by the Chief Justice of the United States. But if you read these statutes, they are about electronic surveillance, wiretapping, intercepting computer communications like emails. They don't provide any protection whatsoever. But we're talking about today the use of drones, the use of unmanned aerial systems. Tort law also is inadequate in this regard. Tort law has traditionally focused on trespass. And of course, to this day, if somebody goes on somebody's property without consent, that's an actionable tort. And it's a tort that's existed at least since the English legal system upon which ours is based. And as I said, there's also a tort of public disclosure of private facts. If somebody, say the media, reveals information where disclosure would be offensive to the reasonable person, and it's not of public concern, there's a tort in that regard. But it's difficult to see the tort that's committed when a private company flies a drone over somebody's backyard and observes what's going on, or a private company flies a drone to look inside somebody's window. Traditional tort law principles wouldn't apply there. Which is why I say when you look at all of these sources of law, constitutional, statutory, common law, there's a need for much more in the way of protecting informational privacy. Privacy with regard to the gathering, the collection, and the dissemination of information. And so this then brings me to the third and final part of my remarks. And I want to talk about the need for both legislative and judicial action. And I think it has to come at both the state and the federal level. Now, in thinking about this, it's important to separate government actions, state actions, from private actions. When we're talking about what the government, through its officers, is doing, then we're talking about what's limited by the Constitution and can also be limited by statute. But when we're dealing with private actors, the businesses who were mentioned in the prior panel, then we're dealing with protections not through the Constitution, but through statutes in the common law. So notice then there can be statutory protections both with regard to the government's use of drones and with regard to private use of drones. And here is a starting point. I want to point to a California statute adopted about 15 years ago that I think, without it being intended to do so, helps limit the ability to use drones and unmanned aerial systems. It's called the California Privacy Act. And what it says is that it is a tort within California, as a basis for civil liability in California, to use video or audio enhancement equipment to gain images or sound that would otherwise require a physical trespass. In other words, what this California law does is create the idea of a technological trespass. Let me tell you a little bit about the origins of the law, since I was somewhat involved with regard to the drafting and then the testifying on behalf of it. After Princess Diana was died in a tragic accident, there were a lot of efforts in California to regulate the paparazzi. And a hearing was held by the California Senate Select Committee on the Entertainment Industry about what could be done to regulate the paparazzi. And people wanted to pose things like, license the paparazzi. Well, that violates the First Amendment. Or limit the ability of the paparazzi to take pictures in public. That violates the First Amendment. And I remember sitting on this panel and almost all of the suggestions saying, you can't do that, it would be unconstitutional. And from the discussion there, it arose that one thing that California could do was say that it's impermissible to use technology to gain images or sound that would otherwise require a physical trespass. It's impermissible for the paparazzi to use a telephoto lens to see in somebody's house when otherwise they could only see that by a physical trespass. It's deemed a technological trespass if the paparazzi use a parabolic microphone and point it at a window to hear conversations that would otherwise require a physical trespass. The California legislature adopted this. Now, at the time this was enacted, no one had ever heard of drones or unmanned aerial systems. But if you think about it, that statute would apply to this technology, because it would now say that it is an offense in California. It's a tort that leads to civil liability for anyone to use an unmanned aerial system to gain visual images or sound that would otherwise require a technological trespass. I think that this law can be a model for states across the country. In fact, right now, the Tennessee legislature is considering an almost identical version to the California law. Senator Dianne Feinstein proposed such a bill nationally. It didn't get very far in Congress. But I think Congress, too, could adopt such a law that traditionally we leave tort law and civil liability to the state system. But this is the kind of legislation that could be adopted to provide us protection, especially with regard to the private use of these drones. I think there's things that legislatures can do with regard to limiting when police can use the unmanned aerial systems. I think the bill that was passed by the California legislature that I mentioned, AB 1367, is a good model. It says that before the police can use these systems to gather information about individuals, they should have to get a warrant from a judge. Notice, AB 1367 did not prohibit the use of drones by the police. What it simply said is that the police should have to follow the same procedure as for all their searches, all electronic surveillance. They should have to get a warrant. I was very distressed when Governor Jerry Brown vetoed this. Now, there's certainly narrower versions of this that could be adopted. You could, for instance, say that the police should have to get a warrant when they're going to use a drone, when otherwise gathering the information would require a physical search or the interception of electronic communication. I think one nice thing of 1367 is it had a broader focus. And again, it doesn't prohibit the police from using technology. It just creates the traditional mechanism of a judicial warrant. My hope is that courts will also act. With regard to private use of drones, courts can develop the common law. And courts can take guidance from statutes like that in California and make it a matter of common law principle. Courts can certainly develop the common law of trespass by technology, saying that it's a trespass to use a drone or other electronic equipment if you're gathering images or sound that would otherwise require a physical trespass. I also hope that the Supreme Court will bring the Fourth Amendment into the 21st century. I think that the court needs to overrule the decision that I mentioned, Florida versus Riley, that it wasn't a search within the meaning of the Fourth Amendment for the police to look inside somebody's backyard through a low-flying helicopter. I have some hope that the Supreme Court might move in this direction from a couple of other Fourth Amendment cases. One from 13 years ago, the other from June of this year. The one from 13 years ago is a case called Kylo versus United States. What was involved here that the police thought that a marijuana growing operation was going on in a house. Marijuana growing emits a great deal of heat. And so the police went to the house and pointed a thermal imaging device at it. And the question was, whether the use of the thermal imaging device was a search within the meaning of the Fourth Amendment. And the Supreme Court, an opinion by Justice Scalia, said that it was a search within the meaning of the Fourth Amendment. In other words, the police would have to get a warrant before using the thermal imaging device. In part, Justice Scalia said it was a search because these thermal imaging devices weren't used very much. But I don't know why that should be decisive. Certainly, the fact that there's more invasions of privacy shouldn't make it more acceptable. I think the part of the opinion that's more relevant for our purposes today is he talked about how much could be learned about what's going on inside the house through the use of the thermal imaging device. Thermal imaging devices can see the outline of a person's body based on the heat that's emitted. It could therefore observe people engaged, he said, in intimate activities. Isn't Kylo then really ultimately about informational privacy? Isn't the court there concerned about the use of technology to gather information that people would want to otherwise keep secret? Otherwise, people could only learn what was going on in the house if they got a warrant, if there was probable cause. And that's why the thermal imaging device was a search. The other case where the court's pointing to the protection of informational privacy was from June of 2014, Riley versus California. In fact, I would suggest to you that this is the most important Supreme Court case in history with regard to what I'm talking about this afternoon, informational privacy. Riley was stopped by a police officer wearing a burnt-out headlight. The officer did a license check. Turned out that Riley did not have a valid license. The police looked in the back of Riley's car and had a large number of weapons. Riley was arrested. A search was done instant arrest. The police took Riley's cell phone. It was a modern smartphone. The officer turned on the cell phone, looked at the pictures there. Some of them were very incriminating as Riley for involvement in recent gang-related activity. The question is, was it permissible for the police, as part of a search instant arrest, to look at the contents of Riley's cell phone? The companion case that was briefed and argued separately, though decided together with Riley, involved a man in Boston by the name of Uri. The police observed him engage in a drug transaction. Right after that, the police arrested him. Officers did a search incident arrest. The officers took his cell phone. It was an old-style flip phone. And the police looked at the numbers he had recently dialed. They traced them, and it was incriminating against Uri. Again, the issue was, can the police look at the contents of a cell phone as part of a search incident arrest? The Supreme Court unanimously ruled that absent a warrant or exigent circumstances, the police cannot look at the contents of a cell phone as part of a search incident to arrest. Chief Justice Roberts wrote the opinion for the court. Chief Justice Roberts began by noting that we generally let the police do a search incident arrest to protect the safety of officers and prevent the destruction of evidence. He said here that information within the cell phone poses no threat to the officers. There's other way to stop the destruction of evidence. But in the most important part of the opinion, he talked about the privacy interest that we all have in the contents of our cell phones. He noted that over 90% of all Americans have cell phones. He said for many Americans, cell phones are an extension of our anatomy. I think he knows my teenagers. He even gave statistics on the percentage of Americans who use their cell phones while in the shower. I don't get it, but that's... He then talked about how cell phones contain the privacies of life. That was his phrase. We can put on our cell phones sensitive information, our medical records, our financial records. He said from somebody's cell phone, it's often possible to access a cloud or a web server and get access to even more information. He said the government can look at somebody's cell phone if they have probable cause and get a warrant from a judge. And of course, as always so with regard to warrants, it's permissible to search without one if there's exigent circumstances. Chief Justice Roberts gave the example of a child abduction or a terrorist situation as exigent circumstances. The reason I mention this case is the Supreme Court was focusing on informational privacy, the privacy interest we all have in the information contained in our cell phones. And this leads me to believe there's a basis for the court to expand this, to create informational privacy with regard to the unmanned aerial systems, to create informational privacy to protect us when they're gathering information about us, when information from them is stored, when information from them is disseminated. I mentioned that Olmstead versus United States was the first Supreme Court case to deal with technology in the Fourth Amendment. It's also very famous for a dissenting opinion by Justice Louis Brandeis. He said there that the greatest threats to liberty will come from people acting for beneficial purposes. He said, people born to freedom know to resist the tyranny of despots. He said the insidious threat to liberty will come from well-meaning people of zeal with a little understanding of what the Constitution is about. I think it's in light of that we have to be so vigilant as this new technology developed to make sure that it's accompanied by privacy protections. Thank you.